Edmiston, I see you. I don't see Ms. Johnson quite yet. Ms. Johnson, you're on mute and your camera may be off, or are you appearing by audio only? There you go.
Yes, Your Honor, I apologize. I had an internet connection error.
We've all been there. With that, Ms. Johnson, we are ready for your argument.
Yes, Your Honor. Good morning.
Morning.
May it please the court, I would like to reserve 5 minutes for rebuttal.
Very good.
Good morning, Your Honors. We are here this morning in regards to Mr. Javier Emmanuel Carrillo for this morning's argument. I would like to begin by stating just a brief resuscitation of the facts. As I'm sure Your Honors are aware, with regards to Mr. Carrillo's case, there was a motion in limine filed by the state at the beginning of the case in this instance, where the court allowed some testimony by the detective to come in, but did not allow all of it. The court limited to the testimony to specific things, and the court did not allow specific areas to come in. Specifically, the court limited to statements contained within the calls, but did not allow specific co-defendant statements, nor any mention of the defendant's rights to come into the testimony. Of course, the defendant in this case was charged in multiple counts of the information. During the trial, Detective Van Camp continuously, we would argue, violated the court's motion in limine and went beyond what the court's limitation was. Additionally, during the trial, the detective testified to certain things that the state argued were verbal acts that were clearly not verbal acts based upon the case law. The detective.
Ms. Johnson,
Yes, Your Honor.
I think we're pretty familiar with what you've been reciting so far, but I have a question for you.
Of course.
As I understand it, Mr. Arguez Carrillo pulled up to the house in his Chevy Cruze and took a bag of tools and walked into the garage and started dismantling the panels on the Kia where they located 15 bags of meth. Does any of this quibbling, if you will, over whether something's verbal acts or not matter when he's got the 15 bags of meth in his hands in front of law enforcement and pulled his car in and walked directly in there and started dismantling the car, just like he knew exactly what he was going to find when he did that?
Well, Your Honor, I think that that's something that's, outside of what we're here today. Obviously, every defendant has a constitutional right to a fair trial.
Of course.
And obviously to competent counsel.
I'm looking for, okay, so you're challenging whether his attorney was competent or not? Is that where you're going?
Yes, Your Honor, and part of it is whether or not his counsel was ineffective on the face of the record. And that goes to our other argument, is that his counsel was ineffective on the face of the record when the counsel continuously allowed Detective Van Camp to testify to all of these outside things, such as when counsel allowed Detective Van Camp to testify to all of these statements that the detective laid absolutely no foundation for, where he was saying such things that I don't have the exact quote in front of me, where about the defendant is, linked to this Javi person, that this organization, and all of these things that the detective laid no foundation for his basis of knowledge for how he knows the street value for narcotics.
Ms. Johnson, let me ask a question that goes to this particular point. Had there been an objection, arguably the state might have been able to lay the foundation that you argue is missing. So in that scenario, is it ineffective assistance of counsel that demonstrates prejudice to the defendant on the face of the record? Or is that something that has to be resolved in a post-conviction hearing where potentially the state can bring in the detective who would be able to lay the foundation that should have been laid at trial and could have been laid had there been an objection?
Potentially, arguably for the street value, maybe. I don't know about his links to Javi or this organized crime or how any of that has anything bearing to do with Mr. Carrillo in this particular case.
But isn't that the problem with trying to determine ineffective assistance of counsel at this point? Because there is quite a bit that's unknown as to what the state might have offered had there been an objection that had been sustained and had the trial court been given the opportunity to rule.
I don't think so, Your Honor. I think at this particular juncture, with the evidence that we have in this particular case, with what Detective Van Camp testified to, I think it's obvious with him testifying with all of this information with regards to Javi and this organized, crime that he was involved in. I think that that's pretty clear that it's, ineffective on the face of the record. I don't think that there's,
it may be let's assume for the sake of argument that there is an effectiveness based on what we see, but how does that establish prejudice on this record?
I think it establishes prejudice on this record because Mr. Carrillo wasn't given a fair trial at that point. Yes, he,
every case there are errors. I mean, it would be an extraordinary thing for a case to be tried with perfection. So does it arise to the level of ineffective assistance of counsel on direct appeal when we don't know what might have happened had there been an objection, and in light of the evidence that Judge Black pointed out in terms of your client clearly being involved in taking the car apart, taking the door panels off? Somebody went and bought more tools because they didn't have the right tools. I don't remember if it was your client or the co-defendant, but went and got more tools to be able to take the door panels off and so forth. So it seems like there's a problem with the prejudice component if we were to try to reach this on direct appeal.
Yes, sir. I believe that there is prejudice on behalf of Mr. Carrillo because he was not given a fair trial with regards to his counsel being, one, ineffective for not objecting to those particular issues at the moment.
Well, Ms. Johnson, let's focus on this because there's overwhelming evidence against your client. That's indisputable. And simply because there's overwhelming evidence doesn't mean that counsel's ineffective. He has to have a good faith basis to make an objection. This detective was qualified for all intents and purposes. Everything that he did was based on what your client told him to do. Rent a house with a garage door, open the garage door for one of the vehicles. And then when that happened, there's 15 bags of drugs. So just because the evidence is overwhelming and they don't object, doesn't mean it's ineffective. What good faith basis did he have to object? And what you claim here is objectionable, inadmissible evidence. Let's go through it.
Well, the objection, Your Honor, is at the beginning when the motion in limine was initially filed.
But the motion in limine, the order says that he cannot talk about Ramon Valenzuela's statements, which he didn't. And he can't comment on the defendant exercising a right to remain silent, which he never did. Right. Everything else was admissible. So what's counsel to do when he has that order? He challenged it, albeit he filed it on the eve of trial at 8:15 in the morning of an 8:30 docket, but yet he still challenged it and it was ruled against him. So what good faith basis does he have to object when it comes in if it's already been adjudicated?
He can still, Your Honor, he still has an obligation to, I would say, preserve the record at that point. When you're filing a motion in limine, I would say yes, you're, preserving the record initially. He would still have to maintain his, objection when that evidence is coming in, number one. Number two, when the evidence is coming in at that point, the jury, I have tried many cases, at that point, when the evidence comes out of the detective's mouth, it has already prejudiced the jury that you're talking about some organization that this person, Javi, is involved with, that your client is involved with.
Well, he's
It's
not
already
selling ring
prejudiced the jury.
baggies. These aren't ring baggies, ma'am. These are huge bags of meth located within the confines of side door panels, everything else that your client opened. Seems to be a little bit more organized than, a street dealer. So I'm still trying to, you make an argument that there's a violation of the motion in limine. I don't see where it's violated at all, because he could not repeat the co-defendant's statements, which he didn't, and he can't comment on his silence, which he didn't. So where's the violation of the motion in limine?
With the organization, if Detective Van Camp had not been permitted to testify with regards to this, unknown organization and what this organization, Javi and all of this information that came out, if he had not been able to testify with regards to that information, then the only, facts that the jury would have is, yes, Mr. Carrillo arrived at this particular location with these, drugs in hand and, or in the compartment, not particularly in hand, but, and, they would not have been prejudiced against him with regards to this other information. When juries hear information about, a drug, organization or other information regarding that, they get, I would say a little bit more antsy with regards to other information. He was also allowed to testify with regards to drug overdoses.
No, that was objected to and sustained.
Yes.
So he was not allowed to do that.
Right. But that information,
And the state's question did not elicit that answer, ma'am. I looked at the transcript. She did not ask, have there been overdoses in the county? No, that was just volunteered by him. So the state didn't ask him that on point. So let's get to the record. That was objected. It was sustained. It never came in. So the jury was never told about some spate of overdoses.
Right. My point is when the jury hears something, they hear it. They don't unhear it. And then when they hear that, they hear organized crime, they hear all of this evidence. They don't just automatically unhear something when they're sitting in a jury box. So they hear all of this evidence together, even though the objection is sustained because, he spits it out, doesn't mean that they unhear it. So when the evidence comes out together, I guess you can say, because it's already out there in the universe, they don't unhear it. Just like you can't unsee something. It's prejudiced against Mr. Carrillo at that point. And on, I have here marked here. Give me just one moment. I have it marked here. I apologize. I thought I had it marked here. That's all I have for right now, Your Honor. And I'll reserve the rest of my time for rebuttal.
Very good. Thank you, Ms. Johnson. Mr. Edmiston?
Morning, Your Honor. May it please
Good morning.
Ryan Edmiston, representing the appellee, the state of Florida in this matter. Again, as all of Your Honors have pointed out, this is a case where overwhelming evidence was presented establishing that appellant was involved in the drug trafficking in this offense. As far as the first issue, whether the trial court correctly or abused their discretion in denying the motion in limine with regard to the phone calls between the appellant and the confidential informant. Again, the trial court correctly found that these were not, this was not hearsay contained on these phone calls, but instead were verbal acts evidence. As you're all well aware, that the verbal acts evidence are extrajudicial statements presented for the purpose of essentially establishing not necessarily the truth of the matter asserted, but to provide context to actions committed by a defendant in a particular offense. Again, the trial court correctly determined that the matters contained on these phone calls, i.e. the address of the house that was rented for the trafficking operation, or the directions how to get there, were not offered for the truth of the matter asserted, but were offered to give context to appellant's actions after hearing these phone calls. That is, arriving to the scene of the offense, exiting his car with tools in hand, and immediately proceeding into the garage where he acted in concert with his co-defendant in disassembling this vehicle to locate 15 pounds of methamphetamines wrapped in individual approximately 1 pound bags. As far as appellant's ineffective assistance of counsel claim, first and foremost, as all of your honors have pointed out, that this is not the appropriate venue for such a claim to be raised, as ineffective assistance of counsel claims are typically very fact intensive. All the claims here are essentially raised on alleged failures to object to particular aspects of Sergeant Van Camp's testimony, and for what purposes that counsel declined to make those objections at that time could have been for a plethora of reasons that would have been, again, fact driven. Whether he felt that it would have been more appropriate to address these matters on cross-examination or in his closing arguments. Again, for that purpose, it's not necessarily appropriate to be raised on direct appeal, and more appropriately, it would be raised before the trial court in a motion for post-conviction relief. And again, first and foremost, again, as was roundly pointed out, these claims, in an ineffective assistance of counsel claim, prejudice is going to be nearly impossible to establish, especially at this point in time, given the vast quantity of evidence presented at trial establishing the appellant's guilt. As far as, if there's no questions, as far as any
Mr. Edmondson, let me ask you a question along the lines of what I asked Ms. Johnson. If this case were to be affirmed and then a motion for post-conviction relief were to be filed, would the state be allowed under the rules for post-conviction hearings, be able to call the officer to theoretically testify and lay the foundation that could have been and maybe should have been laid at trial?
I believe so, Your Honor. And even with that, the officer was qualified and testified to his vast experience in essentially investigating criminal trafficking, drug trafficking organizations. So as far as the price of the street value of narcotics or the makeup of a drug trafficking organization, he testified to years of experience precisely.
Is your argument then that none of these issues, as far as the officer's testimony, would have been properly sustained, an objection would have been properly sustained? Are you saying there was no basis to sustain that?
Yes, sir. In many of these matters, there was no basis because, again, whether there was a predicate for for example, the value of the narcotics, had there been an objection, the state could immediately have asked him how,
Well, but that's the problem. The state didn't lay the predicate if you're saying the state could have then asked him question A, B, and C.
Yes, Your Honor, but again, as you pointed out, this would be something that would be appropriately raised in a post-conviction motion, that they could again bring the officer forward and say, to establish these predicates where this knowledge was derived from. Again, in light of the overwhelming evidence that was presented at trial, even if the trial's counsel's performance was in any way found to be deficient, prejudice could not be established in an ineffective assistance of counsel claim, especially at this point where where such factual determinations need to be still made. If there are no further questions, the state would rely on the arguments and authorities cited in its answer brief and would respectfully request the court to affirm appellant's convictions and sentences in this case. Thank you.
Very good. Thank you, Mr. Edmiston. Ms. Johnson, you have 5 minutes rebuttal.
Yes, sir. Just briefly, with regards to issue 1 is, unlike Mr. Edmiston stated, they were not verbal acts. I think counsel for the government, for the state, often get that misconstrue what a verbal act actually is in reading the case law. It's when somebody makes a statement and a defendant actually acts upon it. It's not where somebody is talking to somebody else on a phone call and then a defendant happens to be at a place or a location when the defendant is not party to that phone call. That is not a verbal act. That is hearsay. That is a common law hearsay rule. So that is completely wrong. And as previously stated, the trial counsel was ineffective on the face of the record for multiple things, for failing to object to the introduction of the phone calls when they were coming in, for failing to properly object to multiple statements made by Detective Van Camp that prejudiced Mr. Carrillo for a fair trial. Because as stated, once that information is out in the universe, there is no way for him to get an actual fair trial at that point. So we ask that your honors grant our motion and reverse the case.
Very good. Thank you, both of you, for the presentation. You may exit the courtroom by pressing the leave button. And again, thank you. The next case is Florida Gas Transmission versus Petrash.